and trademark experience. Today's webinar is called Own Your Brand, a trademark guide for small business owners. I'm going to share my screen and we'll start going through some of these slides that I've prepared for you to help you understand why trademarks are important to your business. So just give me 1 second. All right, so let's get this started. Hold on 1 second, sorry. All right, so whether you're a small business owner just starting out, you're launching a new product, or expanding your reach, understanding trademarks is essential for long-term success. As entrepreneurs, you've worked hard to build your businesses, and your brand is one of the most valuable assets. But how do you legally protect it? That's where trademarks come in. Today's session is designed to help you understand what a trademark is and how it differs from other types of intellectual property. Learn why trademarks matter for your business's growth and protection. Understand how to search, apply for, and register a trademark with the USPTO. Identify common trademark mistakes and learn how to avoid them. Discover how to maintain and enforce your trademark rights. We'll even go through a world-class case study showing how trademarks actually protect your brand. Who is this webinar for? It's for entrepreneurs and small business owners, e-commerce sellers, including those on Etsy, Amazon, and Shopify, professionals and creatives launching personal brands, and anyone who's interested in brand protection. At the end, we'll open the floor for a live Q&A session, so please drop your questions in the chat throughout the presentation. I'll try to get through all of them before the presentation ends. I do want to give a legal disclaimer. This webinar is for educational purposes only, and it doesn't constitute legal advice. If you need personalized assistance, feel free to reach out to me after the session. I will have my contact information at the end as well. Now, let's dive in. Let's start with the basics. What exactly is a trademark? A trademark is a unique word, phrase, logo, sound, symbol, or design that identifies and distinguishes your goods or services from those of others. It helps consumers recognize and trust your brand. But why do trademarks matter? Think about how you instantly recognize brands like the Nike swoosh logo, McDonald's slogan, "I'm loving it," Starbucks, the green mermaid logo, the NBC three-tone chime sound, the Tiffany blue, the iconic blue box. These trademarks make brands instantly recognizable, and they protect them from competitors who might try to copy their identity. Trademarks can be words and names like Nike, Coca-Cola, Apple. They could be logos like this Nike swoosh, the Starbucks mermaid, the McDonald's golden arches. They can be slogans like "Just do it" or "I'm loving it." They could be sounds like NBC's three-tone chime or the MGM lion's roar. The minute you hear the ding, 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 you know it's NBC. Colors and product packaging can also be trademarked. Think about the Tiffany blue or the Coca-Cola bottle shape. Essentially, a trademark serves as your brand's signature in the marketplace. It prevents confusion and ensures that customers know that they're buying from you, not a competitor using a similar name. Before we go any further, I want to clarify the differences between trademarks and other types of intellectual property. We use the word intellectual property kind of as a coverall, but within intellectual property, there's different parts to it. So as I mentioned, trademarks protect brand names, logos, slogans that identify the source of goods or services. Copyrights protect creative works like books, music, film, and art. Patents protect inventions, new technologies, and product designs. And trade secrets protect confidential business information such as trade recipes or formulas. Think about Coca-Cola's secret formula. Knowing which type of protection you need can save you time and legal trouble down the line. But for today's purposes, we'll focus specifically on trademarks and how they help you protect your brand identity. You've likely seen these letters, TM and the R in a circle. But what do they actually mean? You've probably seen them used interchangeably and wondered, are they the same thing? Well, they actually are not. The TM stands for trademark. It's used for unregistered trademarks to claim common law rights. This means that even if you haven't registered the trademark, you can still assert some rights in your geographic area, but you are not considered trademarked for the legal purposes of the USPTO. For that, you'll need the circle R, which is the registered trademark, and that's used only for officially registered trademarks through the USPTO. It provides stronger legal protection nationwide, and it's important to note that if you don't have actual registration with the USPTO, you are not allowed to use the registered R symbol on your products. Now, you may have seen some products that have, sometimes they use the registered R and sometimes they use the TM, and you're wondering, why is that? Can I use them interchangeably? The answer is no. If you're registered, you should always use the registered R. Sometimes a company will have one product registered, and on those logos or names or symbols, they will put the registered R. But they could be in the process of creating a new product line, and because they're not registered, they'll have a TM. Those two things signify where the company is as far as their registration. So you have to know for yourself when you're building your brand, which letters you can use. So most of us start off with a TM, but once we're registered, we should switch to the R, circle R registered mark. There's a few misconceptions about trademarks that I want to go over because I think it's really important, especially at the start of your business. Many business owners make the mistake of assuming that once they've chosen a business name, they automatically own it. But let's bust some of those misconceptions now. A registered business name is not a trademark. Registering your business with your state doesn't mean you have any trademark protection. A business registration with your state simply means that you're allowed to use that name in the state where you're operating your business. But it actually doesn't prevent anyone in a different state from registering that same name with their Department of State. So for example, let's use a company called ABC Co. LLC. They're a shirt company and they registered in New York. They registered with the Department of Corporations in New York, and they run their business only in New York. In New York, they're allowed to use that company name for business purposes. Once they go into the stream of commerce, let's say they start selling online or, through any social media platforms, their name now is throughout the country, throughout the world. They don't have any trademark protection. So if somebody likes what they're selling and they don't trademark their name, a competitor can actually take that name, start their own company, and register that mark for themselves. So it's really important to understand that when you register your name with your state, it gives you no legal trademark protection nationwide. You have to think, where are you going to sell your product? If you're a mom and pop shop only selling your product in one area of, let's say, New York, let's say you just work out of Queens, and the likelihood of your product getting out there, becoming national or global is very small, then you can just register your trademark just within New York State. But if you start selling it online, it's really important to have a federal registration under the USPTO. Also, trademarks are not valid worldwide. US trademarks only provide protection within the United States. If you start operating internationally, you'll need to register your trademark in other countries through systems like the Madrid Protocol, and we'll discuss that a little bit later. Let's say you start having your product manufactured in China, it would be very important for you to have a trademark registration there as well, so that whoever is manufacturing your product doesn't end up stealing your idea for your company and using it as their own in China or around the world. So the reason why trademarks are important for small businesses is because a trademark is an investment in your brand's future. It helps you protect your brand. It prevents competitors from copying or imitating your brand. It provides consumer trust. Customers associate your brand with quality and consistency. Also, it helps with your business growth. A strong trademark adds value to your business and can actually be licensed or sold at a later point. It also provides legal safeguard. Without a trademark, you may have to rebrand if another business claims your rights to your name. So I want to give you an example of a startup that I once worked on. They launched a really cool t-shirt line. At the time, they were just starting out. They didn't have a lot of money, and they thought that they were too small to register their brand name. They didn't think they'd grow so fast. And in the process of building their brand and their business, they let it slide. After 2 years of operating and really growing their platform and their brand, a larger company that was already in the business of making t-shirts took their name, took their idea, and registered it for themselves. Unfortunately, because they were already a t-shirt company, the larger brand was already a t-shirt company, they were already in the stream of commerce, and they registered first, they were able to register that name for themselves. And the company I represented, unfortunately, had to rename and rebrand their entire business. So don't let this happen to you. It's important to identify early on whether a trademark is needed for your business protection, and an attorney can help you identify what competition is out there that may impede on your brand. We're also going to go over a case study called Polaroid Corp versus Polarad Electronics Corp. This is a landmark case in New York, and once we go over it, you'll see really what the importance of a trademark is. Next, I want to talk to you about how to secure a trademark. Let's break down the registration process. The first thing you want to do is conduct a trademark search. You want to check the USPTO database and online presence to ensure that your name isn't already taken. Next, you'll want to file a trademark application with the USPTO. You'll need to provide business details such as your logo, the goods and services that you're claiming. You'll have to provide specimens if the trademark, the intellectual property is already in use. You'll have to show the USPTO how you're using it. If it's not in use, you can actually file for something called an intent to use application. So let's say you're building your brand, but you don't actually have any tangible materials yet to show how you're going to use that trademark. What you can do is file an intent to use and let the USPTO know that you intend to create these certain products. Let's say you're doing t-shirts. So you will tell the USPTO that you intend to use this trademark on t-shirts, and it's kind of a placeholder for when you're actually ready to submit your product into the stream of commerce. You'll already have a part of that protection started. So the USPTO allows for up to 3 years for you to work on your brand, on your product, while having this intent to use application. Within those 3 years, you'll have to renew the application every 6 months. So it's kind of like a check-in. The USPTO gives you 6 months check-in to see where you are in the process of having your trademark ready to sell. So every 6 months, you'll file a renewal. And let's say before the 3-year period, you're ready to go, your product is available, then you will file an application that will actually convert from an intent to use to a formal application that is already in the stream of commerce. Next, you might have to respond to office actions. And what does that mean? If the after filing your application, if the USPTO finds some issues with your application, you may need to provide some additional information or make modifications. Make sure that you reply timely, or else you risk having your application declared abandoned. Usually they give you about 3 to 6 month time period, depending on what exactly you have to respond to. But it's really important for you to keep track of any documents you receive from the USPTO. Prior to filing your registration, the USPTO will file something called a publication, which is a notice of your pending application. This will allow anyone who thinks that your mark may be infringing on theirs or being a competitor, it gives them a chance to raise an objection to your application. This is also how you will monitor for infringement when your mark is registered. There's a publication database on the USPTO site where you can actually go and set up a monitoring service where you'll get alerts. So when a company similar to yours files an application, you'll get an alert and it'll give you the opportunity to raise an objection. And this we'll touch on a little bit later about how to maintain your mark and protect your mark. Lastly, you're going to want to maintain and renew your trademark. Once registered, you must renew your trademark periodically to keep it active. So there is a 5 and 10-year renewal period to ensure that you're still using the mark. During this time, you can also update any changes to the contact information for owners, the attorneys, and it helps you keep your registration up to date. So that is very crucial for you to make sure that your mark doesn't get abandoned. Next, I want to show you how to actually conduct a search. So just give me 1 second to switch my screen. And let me see. Okay. Okay, so Susan, can you see my the USPTO screen?
Yes.
Okay, perfect. All right. So here I want to show you how we go about actually conducting. Sorry, I'm not sure what this is. Hold on 1 second. Sorry. Okay. So I want to go through how to conduct a search. So you'll go on the USPTO's website, and this button right here, Trademark Search System, you'll click on that. And here is where you can write, let's say, the word that you want to trademark, an image, product. You can search up pretty much anything right here. So let's say for our purposes, we'll search McDonald's. So I want to show you what you have to look out for. So as you can see, McDonald's has several registered trademarks in many different forms. And what I want to show you is what you have to look for when you're filing a mark. So let's start with this first one, McDonald's. It's a word mark, which means they're just registering the word McDonald's. Here it says the status is dead or canceled. The goods or services they were trying to register is International Class 42, which is for restaurant services. And the owner is McDonald's Corporation. So we know this is the conglomerate that we know, McDonald's, and they tried to register this mark. So then when we click on it, we can get information on the actual application of this mark. So this is the logo that they tried to register. Now, this was a logo from a very long time ago because they don't use that anymore. And as you can see, the application filing date was September 29th, 1982. So let's figure out what happened here. So the mark is dead and canceled, and it was canceled or invalidated from this registry, and the status is they did not file an acceptable declaration under Section 8. That declaration means that they didn't file the necessary documents to keep up the mark. Now, that could happen for many reasons. Maybe they realized that this logo wasn't, really helping them in any way, so they decided not to maintain it. But for our purposes, I want to show you what information you can find when you do your own search. You can look this up and it explains to you the mark information. So they tried to register the literal mark McDonald's, but they also wanted to register this image right here. And they explain that it's an illustration drawing, which includes the letters and the words. But they try to use the design code of arches, boats, sails, and catamarans. So it seems that they were trying to go all nautical with McDonald's, and it didn't go so well for them. So they decided to let the mark lapse. But what's helpful is for us to see that if we are filing a mark and we find that someone has something similar, we can see what class they're filing in. So here they're filing in the restaurant services class, and it could give you the owner's information. So you can see, is this somebody that is a big company that you're competing with? Is it some small mom and pop shop? They also give you the attorney or correspondent information. So whether if you're applying through an attorney, the attorney's information will be here. If you're applying on your own, your information will be here. Over here, you can actually look up whatever documents were filed with the application. All of this becomes public information. You can open the specimen that they used, and this is what they used to show that they're using this logo and that it's actually in the stream of commerce. So again, these are the things that you'll have to provide to the USPTO when you do your registration, if you decide to do it on your own. Next, I want to show you, so all of these are dead, which means that McDonald's did try to register them. They were registered, and then for one reason or another, they decided to let the mark lapse. Now here, as you see, McDonald's has live registered marks. Now, if we take a look quickly, this one is for restaurant services. So we all know, right? McDonald's is a restaurant service. So they have protection on that name. Now, this one, if you look, its goods and services are International Code 29, which is specifically for types of food. Now, why would McDonald's register chicken, hash browns, potatoes? Why would they identify that? Well, because they actually sell those products that they create. Now, if McDonald's bought these chickens and the hash browns, potatoes that are prepared from someone else, they wouldn't be able to put a trademark on those items because they don't make them. But because McDonald's actually makes these products, they can put their trademark on these particular products. Next, you see McDonald's has a trademark for put on men's clothing, women's clothing, children's clothing. So they have merchandise that they sell, and they want to be able to put their name on it so that nobody else can use their name on clothing. And here you open goods and services, and you see that these are the items, that they want to be able to put their logo on. Next, I want to show you how you can search for, let's say, I actually have, and I want to give a shout out to Liz from Sunny Social. She is an awesome content creator, and so we will be trademarking her logo. And if we look for Sunny Social, what we see are all different types of registrations with the name Sunny. And what we'll be doing for her is checking to see, is there a company that's registered as Sunny Social who is a content creator? So going through these right away, I don't see anything that is troubling. However, if you look, there are 5,713 results. Now, do we really want to go through all of them? I mean, I would, because that's my job. But if you go through this process on your own, this might be a little cumbersome. So a few things you have here, you can actually select whether you want to check live marks or dead marks. You can actually remove all the dead marks, and it will reduce your search results. Then you can search for, you can do an expert search, and you can select what category you want to search in. So if you highlight, if I highlight over the number, it tells me what it is. This number 23 is yarns and threads. This 25 is clothing, 27 is floor covering. So you can go through all of them. And these are both goods and services. So this line right here are all the goods, and over here are will be services. So when you go through your search, First, you want to find out what goods or services you want to register in, and then you can select them, and it'll limit your search so you don't have to search through 1,800 records. But for our purposes, for when I conduct a search, I do go through every record because I want to make sure that when we file the application, we will not get it, we will not have a kickback and then have to go through an office action. So this is how you would start your search. You can also put in a description of a logo. Let's say your logo is going to be a bear. And so here you see the words bear, but if you go through it, you're going to actually see an image of a bear. So if your logo is going to be a bear, you'd have to go through these searches to see, does your bear look like any of these bears? And are they registered in the same classes that you will register in? So the search is a little tedious sometimes, and that's why we do suggest using an attorney, because we know how to search properly to make sure that your registration will not be kicked back. So the big question is, what is the cost of registering a trademark? So the USPTO filing fees were just increased. They are now starting $350 per class of goods or services. So for every class of goods or services, it's $350 if you are using a preset description of goods. So let's say McDonald's, for the restaurant services, they can just select restaurant services. There's no unique description. So it would be $350. But let's say McDonald's wanted to have something more unique. Let's say they were a restaurant service that only offered futuristic meals that float, let's say, for example, and they wanted to include that in their description. Those additional words would cost an additional fee, which right now is an additional $200. So in total, for that registration, McDonald's will have to pay $550 per goods or services if they draft their own unique version of what their goods and services are. Now, if you're going to use an attorney, the legal fees, are optional, but they're recommended, because an attorney who practices in this area understands what goes into a proper search, what goes into the trademark application, and what happens if you do get an office action. There's also additional costs if you're going to do an international registration. So let's talk about some common trademark pitfalls to avoid. Avoid these when you're securing your trademark. Choosing a weak name. Avoid names that are too generic or descriptive, something like best pizza, or something that describes your product is probably not going to get trademark protection. Next, skipping the search. Not checking for existing trademarks can lead to legal trouble. Either you can be impeding on someone else's mark, or you can be in the process of building your brand when someone else is already has that registration, or they're in the process of registering their own mark. The next thing is not enforcing your legal rights. Once you're registered, if you don't monitor and act against infringers, you risk losing your trademark. So I have a client actually where we're in the process of possibly filing a lawsuit against an infringer. My client is a famous YouTube star, and a cake company is using her image on their cakes. They're basically screen printing her image on their cakes. They don't have the legal right to do so. We happen to find this by chance because they are a very small company, and they are not really right now, big enough where it's a big problem, but they are making some money on my client's image. And so the first thing we did was send a cease and desist letter. Now, A cease and desist letter basically tells your infringer that you have a registered trademark, you have the right to use this mark, and they do not. And if they don't stop using it immediately, then you have the right to sue them. And you can sue for any damages you incurred, which is any profits they made on your mark, you can actually get those back. So it's really important to stay on top of monitoring your mark. Next, forgetting to renew your mark. Trademarks must be renewed every 5 to 10 years, or they'll expire, or they'll be considered abandoned. So I actually had a client who, again, in the business of, in their business, they're focusing, they're branding, they're fully immersed in building their brand, and they didn't realize that a notice came in to renew their mark. And so what happens is when you pass that deadline, the USPTO is forgiving. However, when you pass the deadline, the USPTO isn't active. They aren't staying on top of your particular mark. They get hundreds of thousands of applications a year. So they have to stay on top of their caseload. So if your mark misses its application or renewal deadline, it goes to the bottom of the pile. And by the time you realize that you missed the deadline and contact them and try to fix it, it might have already gone into the abandoned pile. And at that point, it's very difficult to get your application back in front of the reviewing attorney. So I just also want to make a note. Once you file an application, unfortunately, the time that we're living in, because this is public information, you will receive some spam. So it's very important to read through everything you receive that pertains to the mark to make sure you're only responding to legitimate documents. If you're working with an attorney, they will be the attorney of record, and they will be getting the correspondence that's necessary so they can help you sift through what is spam and what actually needs to be responded to. If you're not working with an attorney, please just make sure you read everything. Someone will always try to sell you on something that you may not need, so just be mindful of that. So this is just going back to maintaining and enforcing your trademark. There is a way for you to monitor for infringement. It's once you get registered, you could set up an alert. If you do find that someone is infringing on your mark, immediately send them a cease and desist letter, because at least it shows that you are actively trying to protect your brand, and take legal action if necessary. So if you find that someone is infringing on your mark and you let it slide, that company can actually use that to their advantage if you end up suing them later on, because they will show that you had the chance to enforce your trademark and you chose not to. And so that can become a problem for you later on. Now let's talk about international trademarks. As I mentioned, trademarks are territorial. Protecting your brand in one country doesn't cover others. So if you have a trademark that's registered with the USPTO, that doesn't automatically mean that you're protected internationally. If you do want international protection, you can file through the Madrid Protocol, which it's a multi-country filing, and it'll cover the countries that you select. Or if you know you're only working in one other country, you can select it, you can choose an application in that particular country. And the same thing goes for state common law protection. If you're, like I mentioned, if you're a small mom and pop shop and you're really not going to sell your product online, and the chance of somebody finding you, I mean, everything goes viral nowadays, so you'd still want to have that USPTO protection. But if you wanted to, you can file a trademark application only in, let's say, New York, or in whatever state you're using that mark in. So let's talk about this case study that I mentioned earlier on. It's called Polaroid Corp versus Polarad Electronics Corp. This is a significant trademark case in New York. In this case, Polaroid Corporation, which obviously we've all heard of, made cameras and photographic equipment. They wanted to stop Polarad Electronics Corporation from using the name Polarad for its electronic products. The court here had to decide if using the name Polarad would confuse people into thinking that the products from Polarad Electronics were related to or made by Polaroid Corporation. To make this decision, the court looked at several factors, which are now known as the Polaroid factors. And these factors include the strength of Polaroid's trademark. So at the time, Polaroid already had a trademark registration. Next, they had to see how similar the two names are. Then how close the products are in the market. So one company sells cameras and things related to photography, and another company sells electronics, radios, things like that. Now, the court has to determine whether Polaroid might expand into the same market as Polarad. Then they look at evidence of actual confusion among consumers. They would do a test study to see if you showed consumers a Polaroid product with that name and then a Polarad product with that name, would consumers be confused? Next, they would look at the intent behind Polarad choosing their name. Did they choose that name because they wanted to cash in on Polaroid's success? Or did they choose that name because Polarad is their family name? Because they wanted to put their family name on a product and their last name is Polarad. Next, the quality of Polarad's product. Is Polarad trying to build a good brand with a good quality product, or are they trying to, again, cash in on Polaroid's product and success? So for example, if let's say you go to Rite Aid and you buy a brand named item versus a Rite Aid brand item, a lot of times we're going to pick the brand name item because we already know that that brand name has a certain quality that we're looking for, and we don't know whether the Rite Aid brand model product has that same quality. So the quality of a product is really important as well. Next, they'll look at the sophistication of the buyer. And what does this mean? If I am a photographer, or if I understand photography, I am a sophisticated consumer because I know what to look for. I won't be confused between Polaroid and Polarad. I might actually laugh and say, wow, is Polarad trying to copy Polaroid's name? But once I see that Polarad sells electronics, I'll know that they're not the same company. But another consumer, maybe someone who doesn't know about photography or electronics, might become confused. So after considering these factors, the court found that there was a likelihood of confusion, and they actually issued an injunction for Polarad Electronics to stop using the name Polarad. This case is important because it established a comprehensive framework for analyzing trademark infringement cases, which is still used by courts today to determine the likelihood of consumer confusion and protect trademark rights. So even similar sounding names can lead to disputes. So if let's say you're working without an attorney and you want to see if your name is going to impede on someone else's mark, you can actually go through these factors and see what is the likelihood of confusion. I do want to make a point here though. A refusal or an office action doesn't always mean that it's the end for your application. I was actually successful in overcoming several refusals for confusingly similar marks, and have a client now when we're working on a response to such a refusal. That's why searches are so important. Not only do they show you if your mark is already in use, but it can also prepare you for when you want to register anyway, to help you prepare one step ahead. So the client I had a few years ago where we were successful in overcoming a refusal, he had already invested so much money into this brand, and it was a very niche product for a niche group of consumers. But the name was, it wasn't descriptive, it was basically generic, you could say, but there were other companies with similar names, but none in his niche consumer group. And so based on different case law, we were able to show the reviewing attorney that our mark actually would not cause confusion, because the people who are searching for his type of product are not consumers of the other types of products with the same name. Same thing for my client now. She's been working on her product for many, many years. And, unfortunately, she started working on the product before doing a thorough search. And so she invested a lot of money in the product. So when she finally came to me and we ran the search, I explained to her the problems that we may face once the reviewing attorney issues their office action. And so what that gave us a chance to do is start building on our response. We knew we were going to get an office action, but we started to create our response to that office action so that now that the office action came in, we know just how we're going to respond. And I'm quite confident that we are going to actually win on this one as well. So I want to just, I guess we're getting towards almost the end, and I wanted to just reiterate the benefits of a strong trademark. Strong trademark means a unique name. It means a unique logo and something that doesn't automatically scream what your product is. Remember, best pizza. There's nothing unique about it. A strong trademark provides legal protection from infringement. It provides brand recognition and customer trust. It also provides business valuation and investment potential. I actually have a client who we successfully registered his trademark for a logo, and he has been building his brand and actually now has the opportunity to franchise his business. The amazing thing is that now with this franchise, he is able to include the value of his logo in the franchise contract. And that is actually helping him boost the dollar value of his franchise. So I just want to leave you with some closing remarks. Trademarks are a very powerful tool for protecting your brand and securing your business's future. Whether you're just starting out or already established, investing in trademark protection is one of the best things you can do for your business. If you have any questions or need personalized trademark guidance, please feel free to reach out to me at adelina@adelinagrahamlaw.com. I thank you all so much for attending today's webinar, and I wish you success in building and protecting your brand. So now we can jump into these questions.
Adelina, we have Julie who posted a question. If you are affiliated with a large firm, which I am, does it make sense for me to, as an individual, to have my own trademark since I use my company's parentheses brand new TM?
Okay, so I guess I'm a little confused. So the trademark you would register has to be yours. Now, if you're working for a company and you created that trademark during the course of your employment, depending on what kind of documents you have signed as terms for your employment, that trademark may not even be yours. So we can have a further discussion offline because I have a lot more questions I'd have to ask you before I can answer that question.
Okay, and Julie has a part 2 question. Also, when creating a trademark, are you able to use a random photo that you found online via AI search, or do you need to confirm its use first?
Yes, you must confirm first. There's actually, when you're going through the application, you have to swear to the fact that it's something that you created. So definitely make sure you're only registering unique things that you've created. Also, I just want to actually, to that point, I want to say that if you have someone who's working on either a logo, like I know a lot of people now use all of these different companies to create logos for them, I would recommend that they sign a waiver. It's a work for product. So they basically created this product for you, but they have to give up their rights to the product so that when you file the registration, you can certify that this is actually yours and that there's nobody out there that can later put a claim on the product, on the logo, on the trademark name or whatever it is you're trying to register.
Okay, and then we have a follow-up question from Erica. Why am I not able to trademark on the Best of Bay site, even though it is an LLC, but owning the domain Best of Bay site and having the Facebook, the Instagram, etc., is a benefit because anyone who chooses to use the phrase will help to promote our business is what I was told. Not sure if that is correct.
So, Best of Bayside is kind of generic. So remember too, when you're registering words, so best will have to be distinguished. I'm sorry, they will have to, you basically can't register the word best, because it's a generic word. Now, if you had another unique term for the type of business you're running, then that would allow for registration. Best of Bayside, especially with the type of business you're running. I actually know Eric and I know the kind of business she's running. So it's descriptive, and it's generic. And so that's why you probably won't get, you will not be able to register that name.
I believe Shirley had a question. How do you find out if someone is using your mark?
So I showed you how to do a search. So I would start with the USPTO search, and you can type in, you can actually describe the mark there. You can, if it's a logo, you can describe what the logo looks like. If it's a word mark, you can type that in. I would also do a Google search. And to be honest with you, nowadays, you can even do a Chat GPT search. You can put in to Chat GPT the name of your mark or your logo, and ChatGPT can also run a search for you to see if there's any websites, any social media accounts. The only problem with ChatGPT I found is that it's not 100% accurate, so you will need to confirm that, that what they're providing you is correct, but it's a good starting point. If you're going to do the search on your own, my top two obviously would be USPTO and a Google search. You can also search on Facebook, Instagram, and Twitter, TikTok as well, but you don't see as much. TikTok is mostly videos, but I would search the social medias as well. But remember, even if you see your name or logo mark being used on social media platforms, that doesn't necessarily mean that they're registered. So that's why you would have to jump back into the USPTO site to see if the name is actually registered.
So Julie has another question. If you file for a trademark and you provide the logo artwork, is it possible that your slogan may be approved, but the artwork may not?
Yeah, well, it depends. If you're filing two different applications, so I actually recommend for certain clients, I recommend filing separate applications. As you saw with the McDonald's example, they filed many different applications. And the reason why is sometimes a name mark will be rejected because it's confusingly similar or because it's descriptive. But the logo or artwork will be allowed because that's unique. So if you put everything under one application, that application gets rejected. Now you'll have to file a new application. But if you separate your name and your logo into two different applications, then there's a higher likelihood that it'll be approved. With slogan is different. With a slogan, again, if it's similar to somebody else's slogan, that could be rejected. But if your slogan is approved, the artwork could be rejected because the artwork is similar to someone else's, or the USPTO found that it could be similar to something that you can find with AI. So that's why I say it's really important that whatever work you try to register is 100% yours. Oh, and yes, Shirley, I think said, if it's not appropriate, yes, they will not file things that are inappropriate. I mean, to some degree, I've seen some wacky stuff registered recently, so to some degree, they will file stuff.
There's a question there from Genevieve. So I have a debt trademark and was informed another company wants to use it. Would I need to secure an attorney to reinstate, or should I work on this myself?
That really depends on how long ago your mark was considered abandoned. There is a time frame for reviving an abandoned mark, but it will take a lot of work. You will have to show that the mark that you were still actively working on with that mark, and that maybe you just forgot to renew it. But it really depends on how long it's been. So what I would suggest is if you go into the USPTO's site that I showed you and find your mark, contact the attorney, because every correspondence you receive for your mark will have an attorney contact. That's the reviewing attorney. Contact them and speak to them. You know, say that you're self-represented and see what information they can give you. I will say they're kind of like, some of them are kind of like the IRS agents where they're, you know, a little intimidating, but a lot of them are really helpful people, and they do want, especially if you're self-represented, they do want to help. So my first suggestion would be to contact the attorney that dealt with your application and start from there. And of course, if you have any questions, reach out to me and I'll see how I can assist.
All right, Steve has a question there. Can an individual produce T-shirts for themselves with someone else's trademark?
If you have a license to use their trademark, you can. But if you don't have a license, I wouldn't recommend it. I mean, okay, let me backtrack a bit. If you're just creating that shirt like to wear yourself, to wear around the house, and you have their trademark that you can use to put on the shirt, that's fine. But if you start selling it and making any kind of money off of it, or if you start promoting it as your own, that's when you're going into murky water where they can sue you because you are not licensed to use their mark. And no, you can't have someone else reproduce to produce them either, unless they, because technically, if you are a t-shirt, like a screen printing company or something like that, and I come to you with an image, that company should ask you if you have the right to reproduce this image. I know a lot of companies don't ask, but they should, because they can actually be held liable as well for infringing on someone's mark. Okay, then I see Shirley. Can I read that? I have to do a cease and desist then if I find out if others are using my mark. Yes, if your mark is registered with the USPTO, I would absolutely send a cease and desist. So I had a client who had to do a cease and desist, and because the client was a big company and the person that was infringing on their mark was small, they thought, what's the big deal? Okay, they made a couple of bucks on my mark. It's not a big deal. It is a big deal, and I'm going to tell you why. Because that company is small, and they may not be making too much, you know, making money or a lot of money on your mark. But when that company grows and you have already allowed them to infringe on your mark, if you decide to sue them later, they can actually use that as proof that you allowed them to basically, it's kind of like it's a constructive allowance. By way of not taking action, you have allowed them to use your mark. So I would certainly say send a cease and desist. If anything, it puts them on notice that you are aware that they're using your mark. And if need be, later down the road, you at least have the cease and desist to prove that you didn't allow them to use your mark without your authorization.
Adelina, thank you, and thank everyone for taking the time to join the webinar. Again, I'm Suzanne King, even though my screen says Neil Wagner. I am the manager for the Small Business Help Desk program that is funded by Congresswoman Grace Meng. If you want to continue the conversation and you are within her district, you are eligible to receive 5 hours of complimentary consultation with Adelina or someone of your choice that is vetted by Queens Chamber of Commerce. But as you can see, you have received valuable information today. And the session is recorded. And if you want a copy of the recording and the slide deck, please reach out to me or Adelina.
Thank you
Thank you,
so much.
everyone.
I hope you guys learned a lot.
Have a great day.
Bye.
Thank you.